Paul Petras, criminal defense lawyer, New York City. Hello, everyone. Today I'm here to talk to you about appeals and 440 motions. 440 motions and appeals, what is the difference? Which one is right for me or my loved one? Let's start with the fundamentals. An appeal is something that occurs based on an erroneous ruling or something that was illegal that occurred on the record. A 440 motion is based on something that occurred or didn't occur, that was illegal or should have been done legally or ethically, that occurred off the record. So for example, if you go to trial and there is a suppression hearing and your lawyer loses the suppression motion, or the lawyer objects to certain evidence coming into the record and he's overruled by the court, and then she would take an appeal because those two things happened on the record. A 440 motion, on the other hand, is something that occurs off the record or didn't occur off the record. So, for example, the client says, listen, I was not at the scene of the crime and I have this witness who can testify to that, and then for whatever reason, the lawyer does not contact that witness or does contact that witness and decides not to call that witness. That would be something that would be used for a 440 motion because the court has to determine whether or not, if that witness was called, it could have affected the outcome of the trial. And then if so, and if so favorably, then perhaps the conviction could be reversed. So that's one example of when you'd use a 440 motion. But the key is that it's for things that occurred or didn't occur off the record. Okay, so which one is right for you? Which one is right for your loved one? Well, the first thing you always look at is the appeal because there's a time limit on it. You have to put in the notice within 30 days. That's assuming you have a right, of course, to the appeal. Some appeals you have to ask for permission. So there is that strict time limit. And then once it gets up there, you have more flexibility. Once it gets up to the appellate division, you have more flexibility in terms of times because every appellate division has its own schedule. But you really need to get the notice in right away. And you need to begin working on it, obviously, right away, too, because the client is oftentimes incarcerated or suffering the repercussions of the conviction. For a 440 motion, you tend to have more time to do it. Obviously, you don't want to wait forever because courts are going to look at that. Well, why did the person wait? Now, obviously, if there's newly discovered evidence or newly discovered witness, these can be good excuses for why a person waited. But you generally want to also get those done within a reasonable amount of period of time after the appeals. There's no time limit. You could also do it while you're doing an appeal or before, but generally speaking, you want to concentrate on the appeal first. So those are the differences. That's what they're about. Every case is unique. So if you think that your loved one or you need an appeal or a 440 motion, I can be reached at www.petruslaw, PETRUSLAW.com. My number is 212-564-2440. Or you can email me at Paul, Paul, at petruslaw, PETRUSLAW.com. All right, thank you very much. Bye-bye.